Hey everyone, it's Chris Nicolaysen over at Springs Law Group. Wanted to wish everybody a happy new year, and I wanted to walk over one of the new laws that's really going to affect personal injury clients who have been injured in car accidents, also too for people who are trying to do their auto accident case on their own. And so let's take a look at it here real quick. So what we've got it's Colorado Revised Statute 10.3.1117 called Required Disclosures for Liability, and it became effective today on January 1st of 2020. And I want to walk through it so that everybody has a clear understanding of how it can actually help you if you've been injured in an accident to no fault of your own. So it states that not more than 30 calendar days after receiving a written request from an injured party. So this would be a person who's been injured in an accident. You've got to send out a writing. And usually that writing is going to be a letter, a fax, and then if approved by the insurance company as a writing, an email. An insurer that issues a commercial automobile or personal automobile policy of insurance for delivery in this state, the state of Colorado, shall provide to the insured party a copy of the complete policy of insurance, including any endorsements. This is great news because prior to this, one of the only ways that you could actually find out what the policy limits were for the at-fault driver would be to file litigation, to tell them, no, we're not going to settle because I don't know what the policy limits are. We're going to go to court instead. So they have no more than 30 days once you give that writing. By law now. And so then it goes on to state that each insurer that provides or may provide commercial automobile or personal automobile liability insurance coverage to pay all or a portion of a pending or prospective claim shall provide to the claimant in this case would be you, or if you have an attorney, to your attorney, via mail, fax, or electronic delivery, email, within 30 days after receiving a written request from the claimant or the claimant's attorney, which request is sent to the insurer's registered agent, a statement setting forth. So the at-fault insurance has to give you a statement setting forth the following information. And that information is going to be the name of the insurer, the name of each insured party as the names appear on the declarations page. This is huge because, again, the declarations page is that great summary of what the at-fault insurance driver had for coverage. The limits of the liability coverage. So what were their policy limits? Now this helps you because it's going to give you some negotiating power. You're now going to be able to understand, well, what are their policy limits? How much do they actually have? And how much should I request whenever I'm writing my demand? And then additionally too, you can actually get a copy of their policy. An insured party upon written request of a claimant or claimant's attorney shall disclose to the claimant or claimant's attorney the name and coverage of each known insurer and the insured party. And additionally too now, so then we ask, okay, well, what happens if the at-fault insurance company doesn't follow through on this? If they don't provide that information within the 30 days? Well, now there's a remedy for that. An insurer that violates this section is liable to the requesting claimant for damages in the amount of $100 per day, beginning on and including the 31st day following the receipt of the claimant's written request. The penalty accrues until the insurer provides the information required by this section. An insurer that fails to make a disclosure required by this section is also responsible for attorney's fees and costs incurred by a claimant in enforcing the penalty. This is important too because then if you have to go out and get an attorney, so let's say you're doing the personal injury case on your own, you then have to go out and get an attorney to help you get to get this information. Then the at-fault insurance company can be responsible for the attorney's fees and costs as well. And then lastly, the claimant and any attorney of the claimant shall not disclose to any party the information described in subsection 2A of this section, which would be this section here. So you can't disclose that, except that the claimant and the attorney of the claimant may discuss the information with the claimant's insurer. So you can discuss that information upon yourself, but you can't go and announce that to the world. As used in this section, unless the context otherwise requires, claimant means a person that has provided notice to an insurer of a potential claim. So if you were hurt in an auto accident, you have a potential claim. against the at-fault driver and the at-fault insurance company at that point. So this is a new law that is effective. At Springs Law Group, I can tell you we're excited about this change. Now we'll have information, and information has value to it. And so we're going to start using this effective immediately as a way to help our clients out too. But I wanted to share it out with you because I do think it's got value to it, and we wanted to give you some value here today on using it. And then let's go there. So Happy New Year to everybody. We've got a new law that came out in the books. Hope everybody got some value out of that video, and feel free and share it, spread it around. If you have friends that are doing their auto accident case on their own, tell them about that. Let them know that they can actually find out what the at-fault driver's insurance policy is, and then at that point too, it gives them some ability and room to negotiate. And so hope everyone has a great day, and we'll talk to you all later.